We now move on to our second session of day 2, Strategies for Data Governance and Artificial Intelligence, joining up the objectives and implications of the Data Act and AI Act. Now, it's my pleasure to introduce you to Claudia Selli, Vice President, European Union Government Affairs and Head of the Brussels office, AT&T, who will be moderating this session for you. Welcome, Claudia.
Thank you very much, everybody, for being with us today. I'm thrilled and honored to be moderating this very interesting panel and discussion. As you know, the data is an essential resource with the potential to foster economic growth, innovation, and job creation. The digital transformation we are all in, underpinned by the 5G infrastructure, is certainly facilitating a surge in data. It is expected that by 2025, we will have probably 41.6 billion devices connected to the internet. So being a leader in the data space is certainly key. And it's clear that it's one area and one challenge that a lot of policymakers are today confronted with. So the Commission on its end has presented a data strategy and rules that underpin the governance of data, as well as put the people at the center and values at the center of those rules. And so the objective of today's discussion is really to analyze, as it was said, the aim, as well as the cons, probably the consequences of those rules, whether the rules are reaching the objectives. Are they implementable? How are they going to work together, the various instruments? I think those are only some of the questions that probably will be tackled by our excellent panelists and many more. But without further ado, I certainly would like to introduce our speaker, and I will start with Andrea Todt, that is joining us from Luxembourg, the European Commission DG Connect. She is the she is the legal and policy officer on the data policy and innovation unit in DG Connect. And she also works directly with the directors. So Andrea, without further ado, I would invite you to open up the panel with 5-7 minutes introduction. Thank you.
Thank you very much, Claudia, and good morning, everyone. And I've prepared some slides for you in order to make it a little more visual for the introduction on the Data Act. So if they could be pulled up, that would be great. Thank you. Thank you very much, Petra. So again, thank you very much for the invitation to this panel, and of course for this possibility to shortly present the Data Act, that is one of the last major legislative initiatives around data that was foreseen under the European Data Strategy of 2020. And so today I would just like to give you a short overview of the main provisions of the proposal, as well as some context and considerations that led to the articulation of these provisions. So before presenting the different parts of the proposal itself, I would like to just put the Data Act in the wider context of the data strategy. So as you know, and as Claudia also mentioned, the data strategy, which sets out the plan for the Commission for the realization of its objectives around data, is basically our ground document for the policy work in this field. And the main goal of the data strategy is to create a single market for data, a sort of encompassing common European data space with smaller sectoral data spaces operating within. And so one of the main pillars of the strategy is actually the establishment of a cross-sectoral governance framework for data access and use. And this includes the different legislative proposals, such as the Data Governance Act or this new Data Act, as well as other cross-sectoral measures. And in order to show you the structure of the envisaged legislative environment, I would like to just say a few words about the interplay between the different data-related instruments, because there has been quite a number of activities around data in the last few years, but also predating the data strategy. So it's important to see that these initiatives are linked together and that they complement each other, and to see also the intentionality of the framework and the different scopes and objectives of these initiatives. So first, we have the Data Act, which is envisaged to ensure fairness in the allocation of value of the data. And it basically covers all types of data, as well as a broad range of regulated entities. So this is a truly horizontal framework addressing the issues around data in a holistic manner. And of course, we will go into the different parts of it in just a minute. We have also the Digital Markets Act, which focuses specifically on core platform services that are considered as gatekeepers and on their role in reinforcing market imbalances and distortions. And this piece of legislation addresses the issues around data via access and portability. And as you may all know, the political compromise has been reached in the last weeks here as well. So this will also be soon a piece of legislation that will be in force. Then we have the Data Governance Act, for which the political compromise has already been found between the co-legislators on the 30th of November last year. So it is currently in the midst of being finalized for the final adoption, and it will be voted in the European Parliament in April, I think next week already. So this one is very much on the verge of becoming actual law in force. And the objective of this initiative is to ensure trust in data sharing by putting in place certain structures and mechanisms and regulating certain actors that are instrumental in voluntary data sharing, for example, data intermediaries. And to make a differentiation from the Data Act, while the Data Act goes really into the substance around the rights over the data, the Data Governance Act is more about the structures and the processes around data and enabling data flows. So we also have the Open Data Directive, which is already in force, and member states had to transpose them into their national regimes. But this one is very specifically about the secondary use of data that is held by public sector bodies and which can be used or reused by anyone for any purpose. We also have two pieces of sort of background legislation. So first we have the free flow of data regulation, which covers non-personal data, and of course the GDPR for personal data. These apply basically as a basis for all these other instruments. So we often get the questions how these new data-related initiatives interplay with the GDPR, and it's a very straightforward answer. Whenever it's about personal data, the GDPR rules apply regarding the processing of personal data. So they are not modified, they are not amended by any of these instruments. And we finally need to also mention the sector-specific legislation, where additional rules going beyond what have been laid down in the horizontal instruments and which are necessary because of the specificities of the given sector. For example, if you think about the health sector, we have a regulation on the European health data space that it's coming up, or in the automotive sector where there will be a revision of the type approval legislation also in the near future. It's not mentioned in this slide, but of course we have the Artificial Intelligence Act, which interrelates with these data-related initiatives and the Data Act, not in terms of the scope and not on the level of the legal provisions, because they're two completely separate instruments addressing completely different actors and entities, but in terms of practicalities, because one of the main objectives behind the data strategy was specifically to make available as much and as good quality data available for AI as possible. And part of achieving this objective happens via these horizontal data initiatives that actually enable the access to more and better data. So, but when it comes to the Data Act specifically, we aim to address some very common problems around data access and use that we encountered during the preparation of the proposal, and which should be found across sectors in a horizontal manner. So one area of such problems gathered around the maintenance, repair, or the data analytics of data that is generated through the use of connected devices or the Internet of Things, or IoT. such as factory robots or smart home equipment. But apart from these IoT data situations, we have also come across other situations where there are issues of accessing and using privately held data by public authorities in order to be able to fulfill their function and their tasks, or to be able to quickly address emergency situations. And we also saw that cloud switching is still very much hindered by various obstacles. So as a consequence, and in order to address all these problems, the Data Act really aims to regulate who can use what data and under which conditions. So through these rules, its objective is to ensure fairness in the allocation of the value of the data in order to unlock the value of the industrial data in Europe, and thus securing a leading role in the global data economy. However, at the same time, while ensuring that more data is available, the incentives to generate data should also be maintained, of course, in order not to discourage the investments in research and development of equipment or applications that actually generate and create such data. So there is also a balancing act involved here. But to go into the actual substance of the proposal, if you go to the next slide, it gives you an overview of the different groups of provisions in the Data Act. So the most robust part of the proposal addresses the issue of providing better access to IoT data, both in business to business and business to consumer situations. And these are also basically one of the most innovative and prevalent provisions of the proposal. So these rules basically provide an access right to the user of a connected product or a related service and third parties to the data generated through the use of the product itself, thus empowering the consumers and the businesses, specifically SMEs, in relation to the data that they take part in generating. But apart from that, we have a chapter also on contractual unfairness, which aims to tackle such unfairness in relation to data sharing contracts, where the contractual terms are unilaterally imposed on micro-enterprises and SMEs in the B2B context. So it sets out a banned list of clauses that are automatically deemed to be unfair, and the so-called gray list where the clauses are just presumed to be unfair. We also have a chapter on business to government data sharing, which lays down the rules and the exceptional circumstances when public sector bodies could request data from the private sector, such as in the case of public emergencies. Another important part of the proposal concerns cloud and edge service providers, or as they're called in the instrument, data processing services. So the aim here is to facilitate the switching, which is basically the porting or moving your data and applications from one service provider to another, as this is currently being hindered by technical, contractual, and economic barriers. Also, in relation to clouds and data processing services, in order to enhance the trustworthiness of such service providers, there's a provision which may be already familiar to you from the Data Governance Act, and which requires cloud and edge service providers to put in place the appropriate legal, organizational, or technical measures in order to be able to prevent access or transfer of data held in Europe to third countries and third country governmental authorities, where such access or transfer would be in conflict with the relevant EU or member state law. And finally, as a cross-cutting chapter, there are provisions on interoperability and standardization, which really aim to facilitate data flows from a technical aspect as across all the other provisions in the other chapters. So this is what I wanted to give you as a very short introduction. And thank you very much for your attention. Thank you very much for Petra for helping out with the slides. And I'm very much looking forward to the discussion. Thank you.
Thank you very much, Andrea, for this very comprehensive presentation. And I'm sure that we'll go back to some of the aspects that you have mentioned, and that certainly, you know, certainly I have some questions, and it's very interesting to see how the various measures are interacting together. I will move now to the second speaker, who's Francine Cunningham, who's joining us from Bird & Bird. She's the Regulatory and Public Affairs Director. And Francine, I would really, I'm really looking forward also to see from you your presentation and how, what do you think in relation to what Andrea has just laid out?
Thank you, Claudia, and good morning, everyone. Thank you to the IIC for the invitation to speak here. Today, the subject couldn't be more topical, of course. And I have to say, from my perspective, one of the advantages of working in an international law firm is you get information in from different parts of the world. So we have a view on what's happening in regulation in Asia Pac, in Australia, in America, and of course across Europe. And it's clear from that perspective that governments and public administrations and antitrust regulators all over the world are grappling with how to manage the most valuable resource in the digital economy, that is data, of course. And it's already a cliche that data is the new oil, but unlike oil, of course, its value cannot be clearly measured or commoditized. So regulators the world over are really attempting to capture this lightning in a bottle at the moment. When it comes to both data and to artificial intelligence, it's clear that regulators are trying to meet the challenge of managing access to and use of non-personal data as a key resource in this digital economy. Policy discussions are taking place at an urgent level in Europe, the US, Asia Pacific, and basically across the globe. And all of those discussions are really driven by recognition that data is a crucial resource with the ability to drive economic growth and innovation. And this has led to this kind of regulatory reflux all across the world. In Europe, to start with the EU seems driven by an awareness that the region is lagging behind the US and China when it comes to reaping the benefits of the digital economy linked to data access and data use. So with the new Data Act and the AI Act, the EU is trying to construct a new type of internal market, one in which data can move freely and be accessible to European researchers, to public administrations, and also to businesses. And Andrea really gave a very good overview of that. This, in turn, of course, should help businesses, public administrations, and even machines, in the case of AI, make better informed decisions. And these decisions will be based on insights from non-personal data that is available to all. However, this resource-based view of data comes with competing policy objectives. On one hand, there's a desire to unleash economic potential of data by breaking down barriers which stop its efficient exploitation, including access to data by SMEs. On the other hand, there's a real desire to prevent misuse of data by market-dominant players or by competitors or by those who would generate value that does not benefit the local economy. So there's a real dilemma at the heart of the data strategy. But overall, I can see some common approaches in the proposals for the Data Act and the AI Act at European level. First of all, the whole concept of data sovereignty. This concept is a response to growing concerns that citizens, businesses, and governments are losing control of their data. And not just control of their data, but also losing their ability to shape and enforce legislation in the digital environment. From an EU perspective, data sovereignty is about actively promoting those European values that Andrea mentioned, and principles such as data protection, cybersecurity, and an ethical, human-centric approach to AI. So data sovereignty really conveys the idea that users should be empowered to exercise control over their data based on a balanced regulatory framework. The EU proposal for an AI Act also aims to apply EU fundamental rights to the data ecosystem The draft bill, as you all will have seen, takes a risk-based approach to AI systems based on the principle, the higher the risk, the stricter the rules. Among other provisions, the proposal states that training data used for AI systems must be relevant, representative, free of errors, and complete. Now, industry experts have already been saying that in scientific terms, there's no such thing as error-free and complete data. So it's possible that this language will still be modified in the decision-making process. But overall, these principles of transparency and fairness are relevant to both the Data Act and the AI Act. A second common theme for the two pieces of legislation is data sharing. The dominant approach in the EU is now to think of incentives to grow the data economy. A few years ago, some of you will remember, there were discussions about introducing a new producer's right for data. But this approach has shifted the focus from the question about who owns data to who should have the right to access and use this resource and under what conditions. I think that's really where the debate is now at this moment. And the EU's vision of data sovereignty has led to this desire to open up data to all players in the value chain. In particular, this includes SME businesses, of course. At the same time, there's a desire to empower consumers. And this has led to the raft of EU regulation we've seen designed to foster data sharing. And Andrea mentioned many of those regulations on her slides. And then finally, to respond to the Data Act and the AI Act, I would say that companies need to take a holistic approach. So data regulation cannot be understood through the lens of just one legal discipline. It requires a holistic approach that takes account of intellectual property, especially trade secrets, as well as competition law, and of course, the frameworks we already have around data protection and privacy. Both the Data Act and the AI Act will also affect all economic sectors. So they touch a huge range of sectors. To sum up, it's a huge challenge for European business to adapt and comply with the Data Act, the AI Act, on all of these other new regulatory proposals. So the sooner companies start adapting their processes and products to the new regulatory reality, the better. Thank you.
Thank you so much, Francine. And we'll move now. We'll certainly get back to some of the aspects that you raised, which are very, very interesting, including the fact on whether the rules can be implementable or not. But I'll move now to Lina, who's a founder, a legal expert, and a visiting fellow on privacy and cybersecurity issues at the Maastricht University. And Lina, I would really welcome your view also on whether, you know, this regulation is really needed and what your thoughts are there.
Well, thank you so much. And I indeed feel a little rebellious, and I'm going to be quite provocative. What is my style after having been reading through this draft? And I'm not here criticizing in any way that approach, but my fundamental question is that why do we need these kind of layers of rules? As already has been pointed out, they make it a bit difficult for the organizations to understand what are the consequences of their chosen actions. And that is, in my opinion, kind of a root reason why we have rules and laws, that you could make choices and you would understand what is the outcome of those choices. One, of course, fundamental question is the point of view. Are we protecting citizens or organizations? And I would claim that not all of us are working in the organization under pressure from our peers and bosses to deliver certain results, but we all are citizens. And I would like to point out that there's no lack of regulation. And thinking about the very fundamental values and now looking at the Europe, so of course we have a full framework already of those. So we have the human rights treaties, and maybe the best known is or should be the European Convention for the Protection of Human Rights and Fundamental Freedoms. And there, the very first article is about human dignity. It says that human dignity is inviolable. It must be respected and protected, period. And in my very maybe Nordic point of view, when you look at the relationship between fundamental freedoms and constitution and then like sectoral law, what I was taught in the law school is that you cannot make a law that would be in conflict with the fundamental freedoms, or at least you cannot interpret it in such a way that you would violate the fundamental freedoms. And here I can see there's a bit of sometimes colonialistic and very like paternal approach by the new technology. What I have been serving for some 25 years is that we know what's best for you. And I always have thought that that is one of the most dangerous sentences in this world, that it's best for you. It may or it may not be, but I would really want to have a discussion where we are heading towards. I think we need to go back to and take our philosophic hats on and think in what kind of world we really want to live. I think we kind of lost the game already on the physical side if we look at the food. And the whole lovely intention was to enable mass production to avoid lack of food and bring it to the masses at a cheap price. And somehow we managed to mess that thing. We still are struggling to offer affordable, healthy food for masses. There's plenty of overprocessed, very cheap food available, what seems to be guilty for a lot of the problems that we are fighting with. And I'm kind of bit concerned that we will do the same on the mental side, that our life will be so very easy. I mean, our fridge will tell us what we need and our lights will go off and on and we don't have to remember where we put the keys, that we also become mentally lazy and kind of not independent. But maybe enough of this rant and going a bit more back to the basics. And one of the struggles I've seen with the GDPR, what is something that I work now with a daily basis, when I'm talking with organizations, a small and medium and large one from public and private sector, is that misunderstanding of the approach. If you are reading GDPR, for example, from the point of view that it would be a manual for organization, it's a very tedious read. And a lot of organizations are complaining that they are not clear rules for them, but it's not written for the organization as a handbook how to deal with it. It sets a standard level that you should reach. It's really a declaration of human rights. And now I would raise the question when it comes to artificial intelligence, where a lot of nerds tell me that you should remove the intelligence from that pair of words, is that under what legal theory would discrimination be okay just because it's done with new technology? I think there's a clear rules there how humans should be treated, and I don't really care with what kind of instrument they are treated. It still needs to be in line. And I totally do understand that some new technologies bring challenges that you need to think out that what is actually happening there. But problem with a very layered approach means that now you're saying the same thing several times. And if it's identical, my question is that why do you need to repeat it in every single law if it's said already in one place? If it's slightly different, now we have an interest of conflict. I mean, which rule actually overrides the other? And it seems that even though fundamental rights by virtue should be overriding specific laws, they are sometimes forgotten. I think this is more kind of a legal community problem that it's seen as a separate practice, that you have this like human rights lawyers and then you have a tech lawyers. And now they have started talking, what is really delighting me. But I think there should be more talk. And like I was listening to the previous panel and they were also raising that it starts to be fragmented, and I'm all for holistic and harmonized approach. I do love harmonization. And sometimes I see in the practice that if you do very sectoral laws, you forget that that sector does not operate in isolation. They all need something else. If we think about the tax law, it looks at, oh yes, it's a specific field of law, but the tax is deeply in connection, let's say online trade, where you need to spell out what is the VAT and maybe create a receipt of that and have that available for the end user or the authorities. And sometimes I have the feeling that these sectors have not been talking to each other, ensuring that there's a smooth flow of operation. And at the end of the day, going back to where I started, that the small and medium-sized enterprises would have solid understanding what's required from them. I've often said, and I think when we were discussing before this panel, that we all want to see European tech companies flourishing. But if it becomes too difficult for them to understand what's required from them and what is doable, I'm afraid that they will kind of stay in their home turf, or as I often have seen, you first cross Atlantic. You go to USA market because it's a bit of an illusion that you think what are the rules there, and only when you have created enough volume, you come back to the old continent. And I hope that this will change.
Thank you very much, Lina. And you bring in another perspective. You mentioned human rights. You mentioned, are we heading? I know some questions like, are we heading in the right direction? Are we really protecting citizens and consumers? Are we not being too much paternalistic? And I think I have, probably I would like also to bring in another perspective, which is our next speaker. Marco, who joins us from Euroconsumers, is the head of litigation and academic outreach at Euroconsumers. And Marco, I would really welcome your thoughts on some of the Lina's questions and whether you think, that consumers are really being protected in your mind, and what is your view on that? Thank you.
Thanks for having me. Thanks for having Euroconsumers. Euroconsumer is a cluster of consumer organization based in Belgium, Italy, Spain, Portugal, and in South America, in Brazil. We represent altogether more or less 1.5 million consumers. And exactly from a consumer perspective, I would like to emphasize the provisions that are contained in Articles from 3 to 7 of the proposed Regulation Data Act. Also trying to give a first response to the lovely provocative questions from Lina. Why do we need this kind of regulation, and how can we escape a paternalistic approach? A little spoiler, I think just bringing consumers and citizens back to the center of the scene. This is my conclusion, but I will go through it. So why I want to focus on these positions, because these are the provisions that require that the end user to have the full control of the data generated by the devices or the products that they use. And this is absolutely a key point that takes me back to 2017, when Euroconsumers launched the My Data is Mine initiative. In this initiative, it was emphasized that the new scenario offered by the emerging technologies required a totally different approach than in the past. And if we want to fully grasp the potential offered by the internet, it was necessary to overcome the struggle between business freedom and fundamental rights of citizens and consumers. As it has already been said before, that has become an essential result for economic growth, for job creation, for the advancement of society in general. But the exploitation of such data must not ignore the correct protection of the consumers. And as I just mentioned before, just bringing the consumers and the citizens back to the center of the scene, the data economy can really thrive and avoid dangerous degeneration. What we see every day is that data analysis improves decision-making processes. It's a factor for innovation and the prediction of future events. But nowadays, it is necessary to lay the foundation for the development of what we think it's a more responsible and sustainable and respectful of consumers' right data economy through an open dialogue involving institutions and market players. So the data market cannot be seen as an exclusively business-to-business market, given that the final consumers almost entirely represent sources of added value. So the benefits of the data economy must be shared equally between the data holders and the data users who generate that data. So 5 years later from My Data is Mine, looking at the Data Act, we can say that now it's time to move from a My Data is Mine only perspective to a My Device is Mine perspective. And the fact that, for example, Article 3, Paragraph 1 of the Data Act establishes a sort of my device is mine by design principle is absolutely significant. In fact, according to this provision, the data generated, the design and manufacture of the products, they have to be designed and manufactured in a manner that the data generated by their user are by default easily, securely, and where relevant and appropriate, directly accessible to the users. And also according to Article 4, Paragraph 1, where the data cannot directly accessed by the users of the product, the data holder shall make available to the user the data generated by its use of the product without any due delay, free of charge, and where applicable, continuously and in real time. So what we see in these positions is, at least in my opinion, a clear echo of the GDPR provisions about access right as a data subject fundamental right. And also an echo can be seen in the subsequent provision on the right to share the data with third parties, where in some way I think there is a correlation with the right to portability portion to Article 20 of the GDPR, at least for what concerns the pro-competitive purpose. I mean, just as Article 20 has among its purposes to make the transition from one service to another easier, so the provision of Article 5 has the same purpose of set the user free to use the data for any lawful purpose. Of course, this implies to instruct the data holder to provide those data to a third party offering an aftermarket service that eventually may be in competition with it. So, as we can see, this is the way to generate more competition and to fully exploit the potential of user-generated data. So in conclusion, just because I think that my 5 minutes are running out, for a long time, perhaps too long, I would say, we have focused only on personal data and only on personal data as a fundamental right and not as an economic asset. I think it's now it's time to recognize that there is a huge amount of non-personal data out there, that there is life beyond the GDPR. So those data are generated by users, they represent a huge value, and it's time for users to reclaim this without getting entangled in proprietary logic. So the Data Act, I think that goes in that direction. Data must return to being an element of competition, not of monopoly. And in Europe, now we must create the legal framework for this to happen as soon as possible. Thank you.
No, I was just saying that basically, you know, in your intervention, you were mainly speaking of the fact that the consumers should be brought at the center, and that the Data Act is basically creating the framework to allow the consumers and the users to control their data. Maybe I have a question apart from the chat that I will go to immediately, but I wanted to get back to Francine to see how actually, you know, whether those rules that are key for consumers are those at the same time implementable and feasible for businesses. Mm-hmm. Can you maybe, can we have your point of view there?
Sure. Thank you for the question. I think this huge wave of data-related regulation is really an enormous challenge for businesses to deal with. They have to begin now adapting their products, their services, their internal practices to be ready for compliance when all of these regulations kick in over the last couple of years. And it's particularly challenging because we've had already quite a few recent regulations. For example, the DSM Copyright Directive, which is still being implemented at this moment. And yet before the implementation is finished and before we see what impact it's going to have, the DSA is going to be there as well. So it's very, very demanding for European businesses. And it also puts a big strain on the legal counsels and business development teams within companies. I know when I speak to our clients, one of the main questions that comes up is, how do all these pieces of legislation join up and work together? Because we've seen there's quite some overlaps between the different legislation, pieces of legislation, and there's confusion about different terminology in the different proposals. I mean, just to give one example, everyone knows by now that the GDPR refers to data controllers and data processors, whereas the Data Act proposal refers to data holders and data recipients. I mean, that's just one small example, but you do see these different terms and different terminology across the various data-related proposals. So it's not always easy for businesses to grasp all of these complexities. And as I mentioned in my introduction, I think all of these new laws will require a holistic approach, taking in elements of competition law, IP law, and the data protection framework. Now, I have the advantage in my office of having a competition partner sitting exactly to my right and an IP partner to my left, and there's a whole data protection team across the corridor. So when I struggle with the applicability of any of these measures, I can go immediately and ask my colleagues. Very few businesses have that luxury. And I really think this is going to be an enormous challenge for many of your companies in Europe, no matter what their size. Also, very large companies will struggle with this. And spare thought also for national governments. I mean, especially small member states are going to have to make huge efforts to find the resources and also to find the qualified staff to enforce all of these new regulations. And that is also very demanding, I think, on member states.
Thank you. Thank you, Francine. And if anyone else, of course, wants to come in on that aspect, please feel free also to join this type of chat. But otherwise, we have a question that has come through from the audience, and this is from Mike Nelson, who writes that I really enjoyed Lina Kuzniemi comments. Why does the Commission always assume that regulation is the answer? By focusing on control and profiting from data, the Brussels came up with the sui generis database protection directive, which is one of the worst, most counterproductive pieces of digital policy that anyone have ever produced. Do you think it might someday be repealed? Why not fix bad data laws before writing new ones? Now, I don't know whether this question is directly to Lina or if anyone would like to come in and comment.
I'm of course happy to start with commenting, and I would say bad news, or maybe you don't want to hear, but like I said already, I think the GDPR is super clear. And I know there are a lot of people who will contest this. Basically, any data usage. I mean, first of all, I mean, there's a big difference, like already Francine was coming up, and also Andrea, that what data we are talking about. Because if it's fully anonymized, if we truly talk about non-personal data, let's say statistics, that's not in the scope of the GDPR. That's kind of free for hunting, so to speak. But there's, of course, a danger how that is going to be defined. And I was in one conference listening to kind of a Uber nerd from Cambridge Computer Laboratory, and he was asked that how does he feel about this claim that some data is truly anonymized. And he was thinking for a moment, and then he said that he has certain reserves, because if you can now claim as of today that certain data set is totally anonymized, and you cannot in any like available tool or with the like reasonable intelligent brain make the connection back, yes, you can say, but the technology advances so fast that it may be that 2 years from now, that data set that now looks anonymous, by driving it cross with other data set, can reveal that. Having said that, go back that for any personal data use, the list is relatively simple. You need to understand what data you are collecting at the detail level, and the big question is why. Why are you actually collecting and processing that? And that leads you to the legal basis. And then the next question is where it is. And that comes to the maybe data transfer, understanding where the servers are. And then there's of course that who can access it. And that is a very wide question. It sounds simple, but once when you have clarified those, you are much further than a lot of organizations. Where the challenges do come from, why is it so difficult, is that we have these legacy systems that were built. I have sometimes found code from 70s, and now you need to find a specialist to understand what are actually the interfaces in that system. And this means that it becomes very costly to change them because they were never built from this perspective. The intention was to have a scalable, efficient, easy to use, relatively cheap systems that would talk to each other. And this was not even on the table. So those people who built the systems were not stupid or ignorant. Nobody just told them that there can be that kind of impacts once when you open a certain interface, and where does the data really flow. So I'm now handing over for the others who certainly have an opinion in this, but I think that the whole intention of the GDPR was not to block things, but enable them. And at the last, I'm going to quote from IAPP President Trevor Hughes' story where he said that, remember the cars when we had them first, they didn't have brakes. And that's why you couldn't have maximum speed of more than maybe 20 miles per hour, because you had to reserve time for that car to stop before you crashed into something. Once when you invented brakes, now you could increase speed because you had a mechanism to slow down. And that would be maybe a bad parallel about the GDPR, but because you have brakes, you could actually speed up the data processing. Thanks.
Thank you so much. And I think Andrea put the hands up, and certainly, Andrea, we are seeing and hearing different points of view. So please come in and with you know, your opinion as well.
No, thank you very much, Claudia. And first, I would like to completely agree with Lena on that the GDPR, we shouldn't look at the GDPR as something that is stopping things, but something that is enabling them. And I personally come across many times with the notion that not just companies, but also law firms have, that the GDPR is something that stops innovation. And they're trying to pit the GDPR and our horizontal data initiatives against each other, saying one of them is an obstacle and the other is trying to get through this obstacle and try to make more data available and more innovation happen. But I think these are working exactly together in order to be able to do a trusted data sharing, and in order to enable innovation that at the same time provides protection, privacy, as well as such as competition facilitating instruments, as well as consumer empowering instruments such as the Data Act or the DJ should work and act together. But maybe just to go back very shortly to the question from the chat on the sui generis database, right? And I not only feel addressed as a commission official, but also as a former copyright lawyer. And why don't we fix legislation before we come up with a new one? Well, I think in this case, we sort of did both. So if you go to the Data Act proposal, there's Article 35, which basically does not change the database directive, but it codifies the case law of the Court of Justice of the European Union, which basically says that those data sets that contain data derived from the generation of a product or an object is not covered by the sui generis database, right? So the idea was to make it clear that there is no such another obstacle, there is no other layer on the data and the data sets that could hinder the data flows also, because there would be a licensing obligation. And I think Francine already alluded to the data producers' rights, which was something that entered the discussion in 2017-18. And there was one way of approaching things. And this was definitely abandoned exactly for the reasons that Francine also mentioned, that we need to look at it more from an access and enabling point of view. So we do not want to have another layer of exclusive rights. And we also wanted to make sure, which is in compliance with the current understanding and interpretation of the database directive as well, that the already existing exclusive rights do not present an obstacle either. On whether it will be appealed, while this piece of legislation, meaning the database directive, is continuously reviewed So of course, over the years, technology change, environment changes, and of course, older pieces of legislation need to be looked at again more closely. So at this point, it's staying as it is, because our colleagues looked at it as part of the Data Act when we were preparing for that. But of course, in the future, we will need to have a look at it again and see whether it still fulfills its objectives or whether it should be repealed or modified or just kept as it is. Thank you.
Thank you so much, Andrea. And another aspect that I think it's also important within these instruments, both AI as well as the Data Act, is transparency. And maybe whoever wants to respond to that, but maybe Andrea or Francine, do you think that also there are concerns if AI and the Data Act, have transparency clauses that could breach confidentiality? Have those concerns been taken into account? What is your view there?
Well, maybe I say a few words first. Thank you for the question. I think that the whole, all of the issues around intellectual property and enforcement really sit at the heart of this whole discussion around transparency. And the relationship between intellectual property rights and data is very complex. I mean, data are hugely diverse in the way they're collected, they're created, they're stored, and they're processed in many different contexts. So no single intellectual property right applies to all data. And sometimes no IPRs apply to a particular category of data. So it's a very complex situation. I mean, in particular, trade secrets legislation, which is one form of IP right, is very much in the spotlight over the debate about data sharing. And we've seen in Brussels and elsewhere, there's been concern expressed that the data secrets legislation and confidentiality could be used by some industries as a shield to try to avoid opening up their data stores to third parties. Yet trade secrets is a hugely important part of the IP toolkit, and its importance should always be remembered in the context of all this discussion over data regulation. But as a result of all of this uncertainty around transparency and confidentiality, contractual rights and obligations often take center stage in creating the kind of certainty that's required around sharing data. Contracts can supply the kind of controls on access, use, and dissemination of data that many companies require for assurance in this area. And this will allow companies in data sharing arrangements to craft their rights and obligations to fit their own particular circumstances.
If I may just join Francine just for a few sentences to answer your question, Claudia. Indeed, so IP and trade secrets protection have been specifically considered exactly because once you open up something, you will always have the fear that you lose the protection over it. And I think that's very important also specifically for the trade secrets. So we don't want to have data holders to be able to not comply with obligations and to block data sharing based on the trade secrets or evoking their trade secrets over the data or certain data sets. So that is why we have the provisions in the proposal now saying that this cannot be used as a sort of argument against not complying with the data access obligations. However, this would not mean that complying with the Data Act would result in the companies losing actually the protection over their trade secrets. So of course, this trade secrets is a little different from the other IPR because it's more subjective. So it's a secret as long as you do everything in order to keep it a secret. And opening up for access these IoT data, it should not be considered as something through which you can lose your trade secrets protection. That being said, the companies would also be able to enforce the trade secrets also once their data goes down further the value chain. So there are possibilities foreseen in the proposal to have technical protection measures in place, and of course everything should be in line with the applicable trade secrets protection. So it is indeed a very sensitive balancing act, and we have to find sort of like a middle way in providing for and enhancing more data sharing and facilitating this data sharing and data access and use. But like I mentioned, we also need to keep the incentives in the generation or in the research and the development of actual equipment or applications that can generate data. So one aspect of this keeping the incentives or maintaining these incentives is to also ensure that the existing protections over certain categories of data or data sets could be maintained.
Thank you, Andrea. And I see Lina would like to come in.
Hi, yes, very shortly about the trade secret. Yes, from my point of view, working with a lot of like SMEs, that is a super important instrument, especially really going back to the code itself, because in a very simplified way, you could say that copyright is too weak, patent law is too harsh and expensive. So a lot of actually small and medium-sized companies see that something that they have done so elegantly can be actually protected by trade secret better than other like traditional IPRs. This comes to the data, and shortly also my apologies to Mike, who fairly raised that he was talking about the database directive, not the data protection. I totally agree with you, but the whole database protection was kind of an odd child, because it's first and hopefully maybe the last time that legislators decided to protect investment instead of innovation, because that was the way back then when the computer power was so expensive, and simply because somebody could, and after months of work and huge machine power, put the football fixtures in the right order, and that was craving for protection. And nowadays any teenager would probably do that globally in few minutes free of charge. So it's good maybe to question that whether that's already kind of lived past its purpose, but that may be a topic for another panel. Thanks.
Thank you very much, Lina. And we're talking about, a lot of data, volume of data circulating, being collected. And, I was wondering also who was going to be the data broker in this environment. Marco, maybe turning to you, would you see the Euro Consumers Organization playing such a role?
Yeah, definitely. Just going back for a while on the question that we received from the audience, I totally agree that sometimes the overprotection of intellectual property rights is a problem. It creates more problem than the situation that is expected to solve. And absolutely, for the sui generis right of the database directive, it was established to pay a sort of price to the sweat of the brow of the ones who build a database without the creativity aspects. But at the end, I think it wasn't absolutely a good choice in terms of pro-competitiveness of the whole system. Instead, as I mentioned in my intervention before, I think that the Data Act has really good pro-competitive dispositions in it, and echoing also some disposition of the GDPR. I absolutely agree with Andrea that the GDPR in general is not a limitation to the market. It's an opportunity. And especially, for example, as I mentioned before, the right to portability is absolutely a pro-competitive disposition. So once you really succeed in implementing it in a good way, this is a powerful tool in the hands of the final user to switch from a service to another, and so to enable competition. And coming to your question, the role of the consumers organization as data broker, let me say that the fact that, for example, the Data Governance Act explicitly mentioned the intermediary for data sharing. This is something huge. If you just consider what was the status of the art a few years ago, talking about an intermediary for data sharing was maybe something absolutely sacrilegious for to say. But I think instead, in this new perspective, the consumers organization can have a future role as data brokers, because basically the value of aggregated data is undeniable, but isolated data is practically worthless. So as such, individual consumers have therefore little to no ability to fight back while organizing consumers' data, while the consumer organization can instead reach the critical mass and transform the data in a liquid asset to rebalance the digital ecosystem. So this is my opinion on this.
Thank you very much, Marco. And certainly the volume of data are going to be useful and utilized as well by AI. We haven't been talking a lot by AI, but I was wondering whether one of the panelists would like as well to comment on how things, how the rules have been crafted there, and whether they will enable as well, innovation and will make sure that the economy thrives. Is there any one of the panelists that would like to comment on that?
If there's not a huge fight, I will very shortly say just about from the responsibility perspective, because that has been really like the topic, that who should be liable if there are any like negative impacts on any AI. And there has been like some interesting discussions, and I would love to hear from other panelists if you've been participating or heard something else. I've been hearing parallels, like whether it's just a tool, and I think that has been abandoned to a certain extent. Then there's a question, is it a servant for you? Should the master be liable? And then if you think that you would have actually some kind of a semi-independent thing that would do decision on their own, somebody raised a really interesting point of view that should it be looked upon as a kind of employee? Because employee hopefully is much more intelligent than AI at the moment. But if you think about the regime, they typically take the approach that the employer is still liable for the actions and omissions of the employees. Of course, there are the factors and how did you instruct them, and only if the employee independently goes against the instructions and commits, for example, a crime or something as drastic, only then can they be personally liable. I'm not saying this is like a good parallel 100%, but I think the discussion has been evolving from something where you saw it's as kind of some kind of alien that cannot be controlled. But I would be really, really curious to hear from the others.
And Francina's the hand up.
Yes, thank you. On AI, a couple of things strike me. First of all, if you look at the proposal, you have these 4 layers of responsibilities, depending on whether the particular AI system is considered to be low or minimal risk or high risk. And often it's not easy to define whether a particular AI system would fit into a low risk or higher risk category. Often the situation is very blurred, and I think that's creating quite a complex situation. And I just want to give one example about the applicability of the AI Act. Recently, I gave a workshop on AI to a very large logistics company. This is like a major company, and they were struggling with what to do with the proposal and what adaptations they had to make. And one thing they found really strange was the fact that users will be held responsible for anything that goes wrong with the AI system. And they were saying, well, if we buy in an AI system, okay, we may have a manual that goes with it, but we're not experts in that system. So the idea that this proposal is going to hold companies responsible as users for AI systems, they find that something really, really difficult to deal with, and quite a scary prospect. So again, we're back to the subject of the burden on businesses in all of this.
Now, maybe
you very much. Yeah.
Sorry, if I could jump in on this, just to be for once provocative. Looking at all the rules in the AI regulations, I was wondering if it's really possible for an industry to be fully compliant with that at the end of the day, or we are just building a sort of mega fine factory, just like the GDPR sometimes appears to be. So it's really difficult, for example, especially for all the regulations about the high-risk artificial intelligence systems, to be sure to be 100% in line with those rules, because sometimes there are really high general principles, and the way you concretize this principle can be different from a situation to another, and can be really challenging for an industry to be compliant with that. So I think this is a general problem of the regulation of the European Union at this stage. So very good principles, and also the goals are really clear. Sometimes just because the devil is in the details, when you come to the implementation, this can be and have a huge impact on the market.
Thank you very much, Marco. We have around probably 7 minutes left to our panel, as the next one is ready. So I was wondering maybe if anyone would like to react to Marco comments. Francine?
Well, I was really happy to hear Marco say that, because it's really important also that consumer representatives realize the challenge involved in all of these regulations. And it's a really good thing, of course, that EU fundamental rights are really at the center of all of these proposals, and part of the motivation for all of these proposals. But we shouldn't forget at the same time that one of the EU fundamental rights in the treaty is also Article 16, which is the freedom to conduct a business. And there we just need to be careful that we don't create such a complicated regulatory environment that businesses are struggling actually to be able to conduct their business in a normal way.
Thank you very much, Francine. And as we are running out of time, maybe I would invite everyone with one final sentence that you would like to leave the audience with. And I would happily start with Andrea.
Thank you very much, Claudia. Maybe I will be very selfish and use this opportunity for a sort of a promotion, because of course the Data Act proposal came out over a month ago, but we are still in a second round of consultation. So you can go and on our Have Your Say page and comment and share your views on the actual draft proposal. Of course, at this point, our proposal is in the good hands of the co-legislator, but it's very important to have feedback on the actual output and to see the views from all over the spectrum of the stakeholders. We had very, very good feedback and a lot of opinions and answers coming in from the open public consultation. And I would just only encourage everyone to please go and make yourselves heard, because it is very, very important and very useful, not just for us, but also for the co-legislators, in order to make sure that this is a useful and applicable legal instrument once it enters into force. Thank you.
Thank you, Andrea. And Francine?
Well, the last thing I would say is quite simple. For all of the businesses and organizations out there that will inevitably be affected by all of this data and AI regulation, the time to start preparing is now. If you haven't put together a compliance plan, you need to think about it really straight away, because all of these regulations will be coming into force in the next years, and businesses need some time to make all the necessary adaptations. So really get moving now, I would say.
Thank you. Lina.
I'm actually going to echo Andrea. Really happy that she brought that up, kind of for understandable reasons. Yes, please go to the authorities' websites. They're so often they're asking for opinions and inputs, and all the different views are very, very useful in this kind of discussion. So please ask stupid questions and with your own local authorities or regional bodies, whatever, because it's really, really, I think, crucial that there are many different opinions in this discussion that can be taken into account. Don't stop asking why. Thank you.
Thank you, Lina. And not last but not least, Marco.
My final statement is that traditionally there is a sort of a contraposition between industry and consumers organization. I think it's not the time anymore. I think it's the time for an open dialogue between industry and consumers organization, especially in these fields like Data Act, Artificial Intelligence Act. Just through an open dialogue, we can reach better results. And at the end of the day, we all want a more open and contestable market with better product and services for the end users.
Thank you very much, Marco. And I think this sets up for a nice conclusion where even if we heard that there are certainly some rules that can potentially be difficult to be implemented, but from the consumer's perspective, create competition, as Marco is saying, probably there is a middle way ground where we all strive for the same objective, which is to create a better market for everyone, for businesses to thrive, innovation to thrive, but equally to protect consumers and give consumers a choice. We heard a lot of questioning around the rules. Do we really need those rules? Are we not being too much paternalistic? And more importantly, I think Andrea from the Commission as well as Lina were pointing to the fact that it's important to express your opinion so that the points can be taken into account. So don't hesitate to go through to give the feedback to the Commission so that the Commission can certainly understand what is workable or not workable if we are reaching the right objective. But I think that today discussions really lays the ground for all of that. And with that, I would really like to thank you, the panelists, for the very nice and interesting discussion. And thank you also to the audience for being there, listening to us and for asking some questions. Thank you very much, everybody. And with that, I think we will pass on to the next panel.
Thank you, Claudia. Thank you, Claudia, and very many thanks to our panelists for an excellent session. And also, as you said, great interaction from our audience.